Yes, sir.
And Robert Edwin, is it Bellinger or Bellinger?
Bellinger.
Okay. And in this matter, there was a referee hearing recommendation. There was an objection filed by the plaintiff. Scheduled it for hearing on today's date. Both parties, due to distance, other reasons, scheduled for Zoom. Both parties are here on Zoom. So, Ms. Milliken, do you have any witnesses you intend to call?
No, sir.
Okay. What is it you'd like the court to be aware of? And for the record, I will indicate that I have reviewed the transcript, made notes from the transcript, as well as recommendation that was recorded. So go ahead.
Okay. What I'd like is for the court to note that Mr. Bellinger has had our son Gabriel for a total of 25 days in his lifetime. He's had him from the first time he had him from November 6th, 2019, from November to the 8th, he had him off Beaver Island with his parents. Then took him on the island from November 8th to the 15th, just by himself. He was not in contact with me very often. It caused a lot of anxiety for both parties, for our son, for me, the non-communication. He has not had him on that island since November of 2019. He's had him off island four times with his parents in their home. And one time he was off island with just his parents.
Ms. Milliken, though, at the hearing, you offered 6 days consecutive, one time a month.
Right.
And the referee recommendation was 7 overnights, one time a month.
Correct. So with that, I have here that changes by him allowing him to have an extra day, by the referee allowing him an extra day, that's changing my custody when I have sole physical custody.
Physical custody was not addressed. There was no change of custody.
But he gave him only 20 days between seeing him in November and seeing him in December. That's not a full month. That's giving him 14 days within 20 days between. So that's where I drew my objection.
Well,
and
there's a set schedule now, correct?
Based on the referee, yes, sir.
Okay, and so there will roughly be 1 week with father, 3 weeks with you on a 4-week month.
Correct.
Okay, so the first one was to make arrangements based on the time of the hearing and when availability was, I assume. So the referee gave 1 extra overnight out of a potential 30 days a month. He has 7, you have 23.
Even though the defendant and I agreed that 6 days, that's the only thing we agreed on the entire time. So, and the referee changed that.
Okay, your other arguments?
Yes, sir. The referee failed to consider custodial environment with me. I have had sole physical custody. I am the one who's taking care of Gabriel every single day. I'm the one who makes sure he's safe and stable. I'm the one who makes sure his sense of security. If he allows the defendant an extra day, he's not considering Gabriel's sense of security. Gabriel doesn't know the defendant. He doesn't know him, who he is. The defendant doesn't call. He doesn't try to FaceTime. He doesn't ask about our son. In fact, he hasn't asked about our son since August 12th when he dropped him off at my dad's house of 2020. He hasn't asked about our son.
Again, though, the referee didn't change anything regarding custody. He established a parenting time schedule. So you're saying he didn't take that into consideration. He was just establishing a parenting time schedule. Didn't change custody in any way.
Do you agree that Gabriel is safe in my custodial environment versus Rob's, versus the defendant? What is his proof of custodial environment? Gabriel's safety, Gabriel's stability, his love for him. What is the defendant's proof when he doesn't know him?
That's your
based on the
position.
defendant's actions.
That's your position. Your son has spent time with Mr. Bellinger, correct? He knows
25
that's
days
my dad.
of his life.
And he knows that's my dad.
I don't think he knows that.
How old is the child?
19 months old.
19 months old. Anything else?
I also want to bring up where the referee failed to make any notes on what the real argument was in the court that day, where Mr. Bellinger is allowed to have our son in the meeting place. I work until 2:00 and he made a meeting place of 1:30. That's 2.5 hours from me. How is that feasible when I work until 2:00?
So you work every Sunday?
I work every other Sunday, so it would be a Sunday that either I had to meet him halfway or pick him up halfway.
Mr. Bellinger, are you willing to make adjustments for work schedule as to the timing of the exchange?
Yes, Your Honor.
Okay. So if there's a day you have to work, then it would appear that it'd be necessary, if you were working until 2, to apparently change the meeting time to approximately 4:30, it would seem. So that's not something you two can't work out. As long as both parties agree, that's what happens in life and with a child. That you guys will be spending the next 16 years and 5 months or more dealing with. So other than that, any other thing you want the court to be aware of?
I want the court to be aware that Mr. Bellinger has no licensed child care for the child when he's on the island. That he held proof of his job that he had without telling the courts within his timely matter. That Mr. Bellinger didn't answer any phone calls or text messages from September 14th to October 10th. I called him 2 times a day to try to get a hold of him, and he was without answering. So if there was an emergency for Gabriel, how would Mr. Bellinger ever know when he didn't answer a phone call from me from September 14th, 2020 to October 10th, 2020? Also, we were in court on October 14th for this referee. I was in the same town as Mr. Bellinger, and Mr. Bellinger never even asked to see his son when we were in the same town. My son and I were in the same town as him. So no distance, no time. It would have taken nothing for the defendant to ask where his son was or if he could see him.
And would you have agreed to it?
Yes, if he would have asked.
Did you offer?
I asked him in the courthouse parking lot in a text. I asked him why he didn't even ask to see his son. He said, I didn't think that was an option. Why should I always have to reach out to Mr. Bellinger and force a relationship for my son for him without him trying? That's why I tried to call him. I call him. He doesn't call me ever. He doesn't FaceTime randomly. He doesn't text me to ask how his son is. It's me constantly calling him. Just November 19th, Gabriel went into an emergency dentist appointment because he hit his front tooth so hard I had to get x-rays to make sure we didn't have to get it removed. I called Mr. Bellinger. I called him to let him know when he hadn't even spoken to me since that last court date.
Okay. Anything else?
No, sir.
Okay. Mr. Bellinger, your response to the objection?
Okay. As to what she had just stated, that I did not attempt to see him, when we were in the parking lot at Roscommon County Friend of the Court, I did ask. I stated that I didn't feel that it was an option, but then I asked I would absolutely love to, and then afterwards was told, no, I'm not allowed to. As far as the change in time, I'm 100% okay with that. I'm willing to adjust time for working purposes, as long as it's a mutual thing. I believe that this should be a give and a take, not a take. As long as she's willing to work with me on timing as well, because I do have to fly on and off the island, and planes stop at 4:30. So during the winter months, during the summer, they go a little bit longer. In the notes, it's stated that I do not have a permanent residence. Number 11 of her objection. I have submitted through the courts. Where I was renting, that home is now going on the market, so I had to move out of there. I am residing at 26225 Main Street in a 2-bedroom apartment, so I do have a residence. A change in residence, I don't believe that. I feel it was ill-represented that I do not have a permanent residence when I was just changing residence. She stated that I have not asked about Gabriel since August 20th, and I have FaceTimed him multiple times since August 20th. In number 20 of her objection, about I've made comments about possibly not returning the minor child to Agreed. I have never stated that I will not bring Gabriel back, and I have always returned Gabriel to his mother, or actually to both of her, Elizabeth's parents' house, on time, on agreed upon time. I've never deferred from that. Her statement in regards to me only spending my parenting time in Harbor Springs, where my parents, is simply not doable.
I'm not even going, Mr. Bellinger, I'm not even going to consider that. There's not a job around that I'm aware of that will allow somebody to take a week off work to visit with their child. If there was that job, I'd like to have it myself.
Thank you, Your Honor.
Yeah, that's not reasonable.
On the statement that Gabriel does not know me as his father, that's why we're here, to establish parenting time, so then I can have scheduled reoccurring visitation with him to build on our relationship. And I also have an 8-year-old son that lives on the island, and it's very important that he has a relationship with his brother as well as me. I believe that is all I have, sir.
Okay. Just one moment. Just a brief recess and I will grab some.
No, that's not necessary. Back on the record.
Back on the record. Ms. Milliken, you carry the burden here. Do you have anything further you'd like the court to be aware of?
I guess I'm just asking for there to be recommendations from you that make sure, because we don't agree on anything, to make sure that Mr. Bellinger has to provide all safety measures for the child. That's car seat, clothes, because what he was asking from me, from the referee, is that he didn't have to do any of that because he pays child support. Well, he's in debt to child support. So he needs to make his child support on time. He needs to provide safety measures for our child. That's somewhere to sleep, somewhere to eat. He lives above a bar. What's the sense of security for me for that? I mean, he could easily put the kids to bed and go straight downstairs. You know, not saying that he would do that, but that is something that we should consider. Does he have a car seat for the child off the island? Is he going to bring it on the island? Clothes, things like that. Some security measures for the child. Is he going to have licensed childcare when he goes to work? Things like that. That need to be stated, because Mr. Bellinger and I do not agree on anything. Just like the whole time, if I'm working, there needs to be a set time, because we'll never agree on it. We just don't agree on anything. We've tried to agree. We agree one day and we don't agree the next. I want to be sure that Gabriel isn't going to have anxiety from me just dropping him off with somebody he doesn't know for a week. Being scared, wondering where I am, things like that.
Let me ask you, Ms. Milliken, how do you expect that to happen? What do you believe a court can do to prevent that? You have a child with a man that you don't live with. He has a right to visitation with his son. He has a right to have a parent-child relationship.
I think they're starting slow.
I don't have magic, Mrs. Milliken, I don't have a magic wand that can make your son totally comfortable with everything. It's 19 months old. They cry, they get upset over everything and anything. I don't know what assurances you're looking for from the court.
Well, I think 6 days is better than 7, like we agreed upon. That's the only thing that we agreed upon.
Okay. Best interest factors do have to be reviewed. Clearly, in this case, love, affection, other emotional ties existing between the parties involved in the child. In this situation, the father has had limited time with the child, but he has an absolute right to visitation with his child. There has been no showing that he doesn't have love or affection for the child. Clearly, the mother does have love, affection, emotional ties with the child. I don't find that that factor favors either party. There's been no testimony that neither of the parties has the capacity or disposition to give the child love, affection, and guidance. I haven't heard anything that says they can't provide the child with food, clothing, medical care, or other remedial care. If this were a custody matter, the length of time the child has lived in a stable, satisfactory environment would be considered greater. However, this is a parenting time determination. There is no dispute that the child has lived with the mother the majority of his life. However, the father has the absolute right to visitation. Permanence as a family unit of the existing or proposed custodial home. Again, that's regarding custody. In this situation, each party has their own home. Mr. Bellinger has an 8-year-old half brother for the minor child. There's been no testimony regarding moral fitness that would be negative to either party. No testimony of mental or physical health for either party. There is no homeschool or community record of the child because the child is 19 months old. There is no reasonable preference of the child due to the age. The willingness and ability of each of the parties to facilitate and encourage a close and continuing parent-child relationship between the child and the other parent, or the child and the parents. I'll get back to that one. There's no issue regarding domestic violence that's been raised. And then any other factors considered by the court to be relevant. Willingness and ability of each of the parties to facilitate and encourage a close and continuing parent-child relationship. The issue I have there is, Ms. Milliken, I understand you are the mother. You have spent the majority of the time with the child. However, I think you have a perception that you need to control everything and anything, which includes a failure to be as cooperative as possible. In this matter, there was a request by you for a parenting time schedule. This was your motion requesting an established parenting time schedule. The referee heard the testimony and established 7 days once a month as a visitation schedule. You were granted the right to go to Iron Mountain in the initial filing in this matter. So you are at Iron Mountain. Mr. Bellinger resides on Beaver Island. There is no way to make this more convenient. It's a long distance. There is an island involved. It is difficult. The referee, in doing so, made one visitation so that there only has to be travel twice each month. He chose a midway point for the exchange that does not involve you ever having to take the child onto Beaver Island. So any cost incurred in the flights to and from Beaver Island are all on the defendant. So you don't have to incur any cost of a direct drop-off to the defendant's location. Normal procedure would be that you either meet in a midpoint or one party provides all the way to the other party's house and then the other party returns all the way. So in doing this, the way the referee did, he picked the midpoint so that you don't have to travel onto Beaver Island. I don't see where that is inappropriate at all. I don't see where the 7 days instead of 6 days is overburdensome or inappropriate. And if we have a standard 30-day month, 7 days, 7 overnights with the father and 23 overnights with the mother is disproportionate, but appropriate in this situation. Because one visitation is the easiest answer to guaranteeing that the father can establish a parent relationship with the child. And due to the length of travel, it's just easier on the child to only have to do it once per month. The request that he do his visitation at Harbor Springs, as I said, is absolutely inappropriate. No necessity for that. The fact of the matter is, as I stated, I'm not aware of a job that lets anybody take a whole week off in order to have visitation with their child and then still have a job to come back to once every month, 7 days. That's, as I said, that would be a dream job. I wouldn't mind having it myself. So I don't believe there is one out there like that. I believe that the referee did consider appropriate factors when dealing with a 19-month-old and long-distance relationship. For the parents with that child, you can only do the best you can do. Picking the midway point, I believe, is in the best interest of the child, best interest of the parties also. Benefits plaintiff in that she doesn't have to return the child to Beaver Island, that the cost of Beaver Island transports will be with the defendant. The only modification to the referee's recommendation that I can see being appropriate is the time of the exchange as agreed upon by the parties. If the parties cannot agree, then the scheduled time applies. So again, for the future, if there needed to be adjustments in the time, forward or backward, whichever way, the parties should make those agreements whenever possible. But also at the same time, Ms. Milliken, you have to take into account the required travel of the defendant back onto the island. So you guys need to agree when you can. When you can't, the schedule will apply. This is a case where the original distance between the parties was not overly burdensome, probably about 90 miles at the time of filing. Now that has become to the top of the UP and an island by Harbor Springs. So it's not an ideal situation for either party to be able to have great access to the other parent. The other thing that is readily apparent is that Ms. Milliken, you want to control everything, but at this point, your son has a father. He has a right to parenting time. He has a right to make decisions for the child. Those decisions should always be safety first. So I don't think I have to include any conditions regarding use of seats, child seats. Those are required by law. Mr. Bellinger, you understand you have to take all necessary safety precautions?
Yes, Your Honor.
Okay. As to licensed daycare, there is no requirement for licensed daycare. Daycare can be provided by relatives, friend of the family, babysitter, anyone qualified to do the same. There is no requirement that it has to be a licensed daycare. And if Mr. Bellinger elected to, during the parenting time, have the child over with his parents in Harbor Springs at any time, that's allowed also. He gets to choose what he does on his visitation time. Now, I will give you the one caveat. If in the future things have happened that might not be appropriate, those can be raised. And those would be taken into consideration again. However, at this time, there's nothing that makes me think that providing parenting time to Mr. Bellinger endangers the child in any way. I'm certain that as to flights of airplanes versus accident rate of vehicle, it's going to be minuscule compared to massive. So the child is in danger every time the child's in a vehicle, anywhere, going to the grocery store. So I don't see any built-in danger in the flights of airplanes. The safety record of airplanes is significantly higher than safety rate of an automobile. So as to the objection, I believe the referee has made an appropriate recommendation in light of all of the factors to be considered. This was a request by the plaintiff for the establishment of a visitation schedule. Visitation was established. Referee chose 7 days instead of 6, which is not inordinate. It's not inappropriate, not an abuse or abuse of discretion. So other than the one additional caveat to the recommendation, I will make that the order of the court. The only change will be that time for exchange as agreed upon between the parties. If they cannot agree, then the scheduled time shall be considered the order of the court. Ms. Milliken, anything further I can do for you today?
No, sir.
Mr. Bellinger, anything further I can do for you today?
Your Honor, I ask, what is it going to be the first week, the second week of the month? What is the week that I will be spending my time with Gabriel? Is it the first week of the month, second week? I don't know.
It is the second Sunday from 1:30 p.m. to the following Sunday at 1:30 p.m. each month thereafter.
The second Sunday.
So you were given by the recommendation November 15th, parenting time. And then after that, the second Sunday of each month until the following Sunday. So
Okay.
the second Sunday to the third Sunday of every month.
Thank you, Your Honor.
Okay. And it should go without saying, but I will say it for the sake of both parties. If for some reason that week doesn't work, you guys can agree to change that week. It only has to be 7 overnights each month. So if there is something happening that one party would rather have the child another week, you guys can agree to change that. That's how people learn to get along and do the right thing. If in that second week, if Miss Milliken had something happening with her family that she really wanted the child at, and it wouldn't interfere with anything you had planned, you could agree to take the third week of the month, or the first week of the month, or the fourth week of the month, however you want to do it. You guys are capable of cooperating on that. It's just a matter that it has to be 7 overnights each month. So there is an order of the court. If you guys can't agree, it's the order of the court. If you guys can agree and it works out better for each party, then agree to change it and cooperate with each other. That is one of the factors that would be considered in subsequent arguments, if there ever was a subsequent argument, is each party's ability to cooperate with the other. And Mr. Bellinger, if there has been an issue with you not taking calls or receiving calls or making calls, you'll probably need to correct that. So
Yes, sir.
if you want to know what's happening with your child, when she calls, you should answer the phone. If it goes beyond discussion of the child, you don't have to be involved in that. But regarding the child, each of you should be open with the other. If something happens, you definitely notify the other party. Okay? With that, that will conclude the hearing. I'll prepare an appropriate order and send that to both parties. Okay. That'll conclude the